I tell executives to put everything on the table. Everything is negotiable. The executive really has the most leverage at the beginning of the relationship. It's a positive relationship. It's a love fest. It's kumbaya. And he should really seek as much as he can at the start. The other thing that I tell executives is that they really should do the negotiations principal to principal and not have the attorneys involved early on, because then it gets adversarial. There are two instances where it's appropriate to have the attorneys involved. One is to have the attorneys obviously paper the legal concepts in the employment contract. The other instance is to have the attorneys do the hard bargaining with the employer so that the executive can stay above the fray and maintain the collegial relationship he has with his prospective colleagues going forward. Most states will recognize a well-drafted non-compete agreement. A non-compete will be upheld where it protects the legitimate business interest of a company. So how does a court evaluate a non-compete? It's going to really look at it under a rule of reason. What is reasonable? Is it reasonable in terms of geographic scope? Is it reasonable in terms of the duration of time? Is it reasonable in terms of the activity restriction that is placed on the executive? It is really going to be evaluated on the impact it's going to have on the general public, and also does it really impose a hardship on the executive personally. So non-competes are really going to be scrutinized very heavily by the court, and it's something that really should be examined very, very carefully by executives because it has an impact on his long-term ability to make a living. Basically, the company requires the executive not to solicit existing customers or existing employees. Now, existing customers and existing employees are a legitimate business interest of the company that are protectable under the law. Now, a executive really needs to think about that and carve out from that those pre-existing relationships that he has, those pre-existing customer relationships that the executive had before, and carve those out so that when he leaves the employer and goes forward into a new employment situation, he has the ability to reach back out to those pre-existing customers. Now, a confidentiality agreement basically says you cannot use or disclose proprietary information or trade secrets that belong to the company. Again, proprietary information may include customer lists that the executive previously had prior to being employed by the company. So again, it's very, very important for the executive to carve out from the confidential information description his previous customer lists that he had prior going into the current employer. One must think very carefully about the severance and separation agreement provisions that will either be in an employment agreement or it will be part of a separate agreement called a separation and release agreement. There are several areas that really should be focused on because they really have a great impact on the executive when he's leaving. One is medical coverage, the continuation of medical coverage. That's absolutely critical. The other is disparagement. The executive doesn't want to have his colleagues at his old company saying bad things about him after he has left, because that really can compromise his professional reputation. The other thing is mandatory arbitration. I really disfavor mandatory arbitration on behalf of executives, and the reason why is that arbitration can be as expensive as litigation. arbitration does not have the procedural safeguards that litigation may have. Arbitration may be at some inconvenient locality that may be 1,500 miles away from where the executive currently lives. And also, there may be a capricious result from the arbitrator. The other important provision is the prevailing party attorney's provision. In other words, if the company is a prevailing party and wins, then it requires the employee to pay the attorney's fees for having won the dispute, whether it's in court or whether it's for administrative hearing officer. So that's another provision that I would really counsel executive to try to sever from any kind of separation agreement.